Welcome again to this year's E.W. Barker Law and Business Distinguished Lecture. We are honored to have as our guest of honor Mr. Koh Boon Hwee, who is today known very much as the chairman of the Singapore Exchange. Our speaker today is Professor Henry Hu, the Allen Shivers Chair in the Law of Banking and Finance at the University of Texas at Austin. Aside from a long and distinguished career in teaching and research, Professor Hu was also the founder of the Securities and Exchange Commission's Division of Economic and Risk Analysis. He is one of the foremost lawyers in the US on financial innovation. Many of us who studied at US law schools have come across his articles on derivatives, hedge fund governance and voting, and most recently, cryptocurrency. He was perhaps one of the first interdisciplinary scholars in law and finance and brought that expertise with him to the SEC. In recognizing one of his articles on hedging and corporate governance, an important index of gold mining shares uses as its ticker symbol HUI or HUI. We eagerly await his lecture on disinterested shareholder vote, which our guest of honor, Mr. Koh Boon Hwee, will say more about next. It is interesting that exactly a year ago now, the US listing rules were changed so that larger material and interested person transactions, which used to require a disinterested shareholder vote, now only requires board approval. They have moved a higher requirement for listed companies back to what it is for all companies under their Companies Act. So we may have passed a high point of the idea of a majority of the minority, something that recently we have been talking about in the context of the OCBC takeover of Great Eastern, which Mr. Koh, I think, would have been involved in, right? So it's now my privilege to introduce Mr. Koh Boon Hwee as the guest of honor of these otherwise more traditional legal proceedings. Modern corporate lawyers do not and cannot simply nod when it is said that they have to be more interdisciplinary, and so much financial innovation requires knowledge of finance, economics, and science. The presence of Mr. Koh as guest of honor today attests to that. He's today, as I said, best known as the chairman of the Singapore Exchange, who has called for greater market liquidity in order to enhance stock market liquidity. This requires a change of mindset towards the entire ecosystem. As many of us know, there's a massive review going on as to how to improve market valuations on the secondary market and more fundraising on the IPO or primary market. Mr. Koh is, of course, central to that review. But while he has been associated with finance for a long time now through private equity, as well as his positions in various asset management firms, Mr. Koh was first and foremost an engineer who studied at Imperial College. He must then have been one of the first Singaporeans to obtain an MBA with distinction at Harvard Business School. He later rose to become managing director of Hewlett-Packard and then executive chairman of Witherlam, which was part of the largest paint maker in the world, Nippon Paint. So he has been on both sides of the corporate finance equation and is probably best placed to take what are, in his words, the bold and decisive actions needed to revive our stock market. To be fair, it may not be that our financial centers, like many others, including London, are getting it wrong. Rather, that it's just that the US markets, which Mr. Koh is very familiar with, are in that sweet spot where things are working well for them. But it's also at this moment that we, or more accurately they, have to guard against complacency, as things can change very quickly if they do not continue to work hard to preserve fair, efficient, and transparent markets. Needless to say, there are many calls on Mr. Koh's time, and he's also served as non-executive chairman of some of the most iconic Singapore companies like Singapore Telecom, Singapore Airlines, and DBS Bank. I dare say that no Singaporean has actually been chairman of all these listed companies in Singapore. We are grateful that he's taken time from his busy schedule and remarkable career to be here today in our historic campus that the NUS Law School will sadly vacate at the end of the year. So thank you all for being here, and please welcome Mr. Koh Boon Hwee.
Welcome, ladies and gentlemen. I was really sad when I was walking through here to be told that all of you are about to vacate this campus. I just think that, this is one of the most historic parts of Singapore. I happen to live right around the corner, so I have no idea who's going to become my neighbor. But I would like to thank the E.W. Barker Center for Law and Business for their kind invitation to this wonderful event. I am honored to be standing here before an audience of highly esteemed lawyers and academics. And I'm looking forward to hearing from our distinguished speaker, Professor Henry Hu, today on the concept of disinterestedness. I can't think of a word with more syllables in shareholder voting, and it is both timely and I think topical. Professor Henry Hu first came to the attention of non-lawyers in a series of articles in the Financial Times on empty voting around the time of the global financial crisis. This phenomenon came about because hedge funds have increasingly, through the use of derivatives, found it easy to separate voting rights from economic rights of corporate securities like shares and bonds. This is something that we are also familiar with here in Singapore. I am told that he came out to Singapore to speak on this in 2007 and ended up appearing on Channel News Asia. So we have clips of those. As someone who is now involved in financial services, what is of greater interest is that he was then put in charge of financial innovation at the US Securities and Exchange Commission from 2008 to 2010. I think we can all agree that financial markets should be free to develop in a way that is fair and transparent. It was Churchill, after all, who once said that he would rather see finance be less proud and industry more content. He said that in 1925, and here we are, we're still in exactly the same position 100 years later. Nothing has changed. As chairman of the Singapore Exchange today, we have been trying to find ways to help SMEs come to the market through a listing process. The pipeline looks more promising than it has been for some years now. But frankly, IPOs are more likely to happen if share valuations were more reflective of the value of the business. And higher valuations, in my mind, will actually help to crowd in other companies from around the region for listing. If we in Singapore do not support our own companies, why should we expect foreigners to do so? As I have said publicly for a while now, this means that we have to accept more volatility in our markets, as that goes in tandem with higher expected returns. This in turn, therefore, attracts investors with higher risk appetites, which includes many institutional funds. Navigating between the needs of different constituencies has been a challenge for the SGX. It will remain a challenge because while we are also a listed company focused on making a profit for our own shareholders and investors, it is my belief that the SGX also has a social enterprise role by virtue of the fact that we are right here in Singapore. We should be helping the development of our industries by allowing them to raise financing and also ensure that Singapore will remain a vibrant capital market well into the future. That is something, by the way, that is absolutely not assured in today's world because it is changing very rapidly. My own experience with disinterested shareholder voting is similar to what Professor Henry Hu will discuss later with hedge funds that today may hold out when voting on corporate actions. You read a lot about this, actually a lot more in the US, where you have a lot of activist funds. Their interests may not be fully represented by the shares they own. At the same time, majority shareholders clearly cannot vote in certain situations. But I believe the issue is not just one of conflicts of interest, which afflict majority shareholders, but there may be situations where even a minority shareholder, like a hedge fund, may have an influence that distorts voting outcomes, and they may not, in fact, represent the interests of the broader, ordinary shareholder community. The goal, therefore, is to find a path for the company to achieve its best interest when that could be blurred by the many strategic games that can be played, particularly in takeover situations with today's financial instruments. Like the rest of you, I cannot wait to hear what Professor Hu has to say about how we can discern which votes of institutional investors are aligned with ordinary shareholders and who are the truly disinterested. Thank you all very much for your attention. Thank you.
Many thanks to Professor Tjio for having me back to Singapore after 18 years. Singapore's progressed so much, and it's a real honor to have Mr. Ko here today. I took a look at his bio and astounded by how he is, in fact, the master of everything. And in terms, and I thank all of you for being here. Now, whether you graduated from law school a year ago or 40 years ago, there's one thing that you all know, which is like the foundational premise for shareholders having the vote. The basic idea is that the shareholder has an economic interest in the shares and will use the vote that the shareholder has to try to get the share price going up. So, for instance, voting for good directors and voting against bad director nominees, voting for transactions for mergers that would increase, in a sense, your shareholder wealth, right? Increase the share price, and vote against the mergers that would basically harm your shareholder wealth. But notice, in terms of this foundational premise for the shareholder vote, it assumes that economic rights are coupled with voting rights, that they are conjoined. Now, that's in theory. As many of you know, in law school, in terms of the standard kind of focus of corporate governance, basically from the 1930s to the 1970s, was on the so-called Burley means hypothesis, right? That is, in theory, shareholders have all this power, but in fact, there's a separation of ownership and control because all these individual investors have very little incentive to vote. They may not have expertise to make the right voting decisions. And so as a result, while in theory, management is basically an agent of the shareholders, in fact, managements run everything, right? There's a separation of the ownership of shareholders from the control, the actual control of the corporation. So in effect, the shareholder vote was mere ritual, a piece of kabuki theater, rather than anything more than that. Well, basically, beginning around the 1970s and thereafter, the institutional investor ownership expanded radically. In the US, basically with the passage of the 1974 ERISA Act. And so there were a lot of early hopes at that time. In the 1980s, there was a Forbes magazine article that was titled, "Goodbye to Burley Means." The idea was, hey, these institutional investors, hey, they have the incentive to vote if you have millions of shares in a company, right? Real incentives to vote. And you have the expertise, or if you don't have the expertise, it's worth it to hire the expertise to analyze whether you should vote for a particular director or a particular merger. Now, those were the early hopes. Now, there are lots of problems. Okay, it turned out that those early hopes were misplaced, that in fact there are all kinds of issues in terms of whether institutional investors are really fulfilling the roles that people had hoped for. Well, what today's lecture is basically focused on is kind of one of the ways in which, in fact, there are some real issues, complexities in terms of how institutional investors vote. And in terms of the source, Basically, there are all kinds of reasons why the motivations of an institutional investor may be misaligned, right, with shareholders. For instance, the pension fund that holds shares may also happen to hold shares in the company that's part of a merger, and they're hoping they don't want to vote against a merger their client wants because they're never going to get any more pension business, right, from that company. So all kinds of reasons. But I want to focus on one particularly important reason, okay, which is the motivational misalignment that can result from the decoupling, the separation of voting rights from economic rights. Now, in terms of the first generation of that, basically revolved around very clever hedge funds, basically beginning about mid-2005 or so. And they were using motivational misalignments, using decoupling, the separation of voting rights and economic rights, as a profit-making strategy. They're intentionally doing it and using that financial engineering to try to make money. And I'll illustrate one example. There are lots of ways of doing that, both on the equity side and on the debt side, okay? But I want to just illustrate one simple example involving Perry Mylan, okay? The Perry Mylan Labs transaction. Now, that's motivational misalignment coming from as a strategic matter and basically involving hedge funds, clever hedge funds. What is interesting, and one of the things that we basically argued, we first looked at the phenomenon, looked at this in a 2023 article, and we elaborate on our thinking in this recent article, which is available for downloading, basically pointing out that, hey, there are certain transformational changes in terms of conventional asset managers. I'm talking about Vanguard, State Street, BlackRock, right? The big three. Not just hedge funds. And in terms of these transformational institutional investor changes, these motivational misalignments come up not really as a matter of strategy, profit-making strategy, but because of larger developments, okay? And I'll be talking about some of these larger developments causing the problems in terms of these mainstream institutional investors. And basically, they stem from two different categories of things. The financial stake side and what we refer to as the organizational voting dynamics side. Don't worry about terminology right now. And I point out as one example of how these motivational misalignments of mainstream institutional investments can really matter is with respect to like the key legal doctrine in the US to deal with, in effect, motivational misalignments. And that's the so-called disinterested shareholder doctrine, a long-standing judicial doctrine. And we basically point out, hey, this long-standing doctrine basically developed well before institutional investors and has been completely frozen in time. That is, it doesn't realize modern realities. And what we point out is, hey, there are all kinds of substantive and procedural problems associated with this kind of doctrine that really hasn't been updated. And so we offer a reconceptualization, a substantive and procedural reconceptualization of the doctrine that we think can be adopted by judges without any statutory changes. Okay? That would help, not a complete perfect solution, that would help deal with this issue. Okay? So what I want to do is first start by talking about what's this business about decoupling? Well, what does it mean? And how does, for instance, this early hedge fund behavior, Perry Milan, kind of illustrates some of the issues. Say that you are a shareholder that owns 1 million shares of a company, okay? And let's just call it the host company for reasons that we'll get to later. 1 million shares of a company. And let's assume a typical company, 1 share, 1 vote. So I'm not talking about companies with dual class shares and so forth. Okay? 1 share, 1 vote company. So he has 1 million shares and 1 million votes, right? Now, what if, and he has incentive, of course, to see the share price go up, right? Okay, how about this? What if instead of simply holding the 1 million shares, he has sold short, let's pretend, 250,000 shares, okay? 250,000 shares, or bought put options, that basically analogous to having sold short 250,000 shares. Notice, at this point, it has economic interest in the shares equivalent to 750,000 shares, but it still has the 1 million votes, right? So this is why we introduced this scheme decades ago, and under the analytic framework that Professor Bernie Black and I introduced, we refer to this person in this context, for instance, as an empty voter. Why did we call this an empty voter? Well, because notice, his voting rights have been emptied of the corresponding economic interest, right? He only has 750,000 share economic interest, but he has 1 million votes. Let's take this further. What if instead of selling short 250,000 shares, he sells short 1.5 million shares, or buys put options equivalent to 1.5 million shares? Well, in that case, his economic interest in the company is a negative 500,000, correct? But how many votes does he have? Heck, he still has 1 million votes. So notice, this is what we refer to as an empty voter with a negative economic interest. There's something really perverse about this. Notice, you have 1 million votes, and rather than voting for good directors, you want to vote for Mickey Mouse as the director. Or instead of voting for good mergers, you're hoping the company would be proposing a really terrible merger so you can vote for it because the share price would go down, right? So the empty voter with a negative economic interest is kind of like the extreme version of empty voter. Now, in terms of whether this happens in real life, yes. Let me illustrate. So, and if I'm going over stuff that you're already familiar with, I can certainly speed it up. So, do let me know. So, there's this company called Milan Laboratories, whose shares are publicly traded, I think, in the New York Stock Exchange. Okay, and there's this hedge fund called Perry that happens to own something like 9.9% of Milan Labs shares. Okay, and just like everybody else, Perry would like to see the share price go up. Okay, well, I'm sorry, got it wrong. King Pharmaceuticals, called King Pharmaceuticals, okay? It owns 9.9% of King Pharmaceuticals. Perry, like everybody else, wants the share price to go up. Well, there happens to be a company called Mylan Labs, also a manufacturer of generic pharmaceuticals, publicly traded, and it decides it wants to buy King. Okay? And let's assume that the trading price of King was $26 a share. And the way Mylan Labs structured it was as a tender offer, okay? And they offered to pay $35 a share, okay? $35 a share. So Perry would stand to make a ton of money, okay, if the acquisition goes through. Now, but there was a kind of problem that Perry was worrying about. The problem was this. The way they structured the deal, Mylan Labs had to convince its shareholders, Mylan Labs shareholders, to vote for the deal. And Perry was really concerned about that. Perry was really concerned about it. Hey, $35 versus $26, you know, they may be overpaying. So Perry was concerned that the Mylan Labs shareholders would vote against the deal. Okay? Now, what did Perry do? Well, what Perry did was it bought about 9.9% of Mylan Labs. Oh, you know, for the obvious reason that, hey, if it owns 9.9% of Mylan Labs, hey, he's going to vote 9.9%. So, hey, tip the vote, right? But that's not the interesting part. That's not the interesting part. The interest part is this. Simultaneous with buying 9.9% of Mylan Labs, it bought put options and other derivatives that zeroed out its economic interest in Mylan Labs. It couldn't care one bit what happens to the value of Mylan Labs. So think about this. If it doesn't care about the value of Mylan Labs, hey, he would vote for a takeover even if it were $1,000 a share, right? Because, hey, okay, the value of Mylan Labs is destroyed, but so what? He doesn't care. He's completely hedged. But he will make tons of money on this side. So we use, in the initial law review article that Bertie and I wrote, we refer to Perry as having an overall negative economic interest in Mylan Labs as to this transaction. Why? Hey, because it has the incentive to actually vote in ways contrary to the interests of the other shareholders in Mylan, right? So if you consider so Perry's, notice, and this is where the formula comes in, okay? Notice Perry has a negative overall economic interest in Mylan because of the net effect of the holdings of Mylan Labs, which we call the host shares, right? The ones in the company that he's voting in, right? And B, coupled assets. Well, what are the coupled assets? Well, the put options he owns, right? And the related non-host assets. Well, that's the shares in King Pharmaceuticals. Okay, so notice in terms of the overall impact of the financial stakes, right, that it has a negative economic interest, and that's very worrisome. I said this occurred in the real world. Well, I lied a little bit. What happened was it turned out that King Pharmaceuticals had all kinds of accounting irregularities, and nobody wanted King Pharmaceuticals anymore after that. Okay, so in fact, it never took place. Okay, so I'm not being completely truthful. Okay. Now, that's an example in terms of, notice, a hedge fund deliberately using decoupling for profit. All right. Now, in contrast, in terms of institutional investors, basically, it's a byproduct of larger phenomena, okay, in terms of how the motivational misalignments come up. And one has to do with the nature of the financial stakes that mainstream institutional investors, such as the big three, have. And the other one, and I'll primarily focus on that part in terms of, because it's a little bit simpler, as well as certain kind of institutional investor-specific policies and procedures, ranging from certain ESG-oriented policies to various share lending, share borrowing policies, to voting policies and procedures. I'll touch on that in a little bit. So looking in terms of the financial stakes part, in terms of how that comes about, well, one of the big changes, transformational changes in finance, of course, was the emergence into public view in the 1970s of the virtues of indexing, right? Passive investing, that, you know, it's tough to find the proverbial $20 bill sitting on the sidewalk, right? And basically, in terms of this indexing, let's think about the effect of indexing, okay, on the chances of you happening to own both companies, parties to a merger. If you are tracking the S&P 500, hey, inevitably, if there are two mergers involving S&P, you own shares in both, right? And in terms of indexing, there's kind of an inflection point around 2015. So beginning in 2015, every year since, the percentage of assets, the U.S. stock market, that were basically using indexing or similar passive strategies has increased every year since 2015. And as of, for instance, 2021, over 33%. Okay? So just from the sheer rise of indexing, right, the motivational misalignment comes up. It's not anything nefarious. They are not acting the way Perry Myland is. They're not using motivational misalignment for strategic purposes. A second kind of financial stake-related reason is the incredible growth of asset managers, especially the biggest asset managers. Okay? So to give you a sense, in terms of, I should mention, like in the U.S. in 2023, the percentage of money of U.S. mutual funds and ETFs using passive strategies exceeded, for the first time, those mutual funds and ETFs using active strategies. Okay? So, in a sense, this problem comes up more and more often in terms of having both. Now, in terms of a second aspect is the incredible growth of asset managers. You know, the more, you know, if you're especially if you're a really huge asset manager, you're not just going to have an S&P 500 fund. You'll have a Russell 2000 fund, tons of other funds, right? So virtually, if you're talking about a big asset manager, in lots of deals, in so many deals, they will have both. Okay, and in terms of give you a sense in terms of this growth and concentration, by year 2023, State Street was managing $4 trillion, Vanguard $8 trillion. Or in terms of the share of assets managed by the big three, those two plus BlackRock, by 2022, it reached 55%. Think about that, just three entities, okay, 55%. Okay, so in terms of this disinterested shareholder doctrine, the basic idea is this behind the doctrine, okay? That is, in certain contexts, not all, but in certain contexts, such as, for instance, when there's a controlling shareholder, okay, in terms of evaluating whether or not a merger would be allowed, a judge who would normally use a strict standard of judicial review, what in the US would be referred to as either strict scrutiny or the somewhat lighter enhanced strict sorry for the reason, enhanced scrutiny or strict scrutiny, a judge would actually look at, for instance, the substantive fairness of the deal and also procedural fairness in terms of the deal. Because the concept was, hey, you can, and in terms of determining that, you can't let somebody who does not have a positive economic interest in the company vote, right? Because if a share, that vote to be counted, because if you count the shares, right, with somebody who has a negative economic interest, hey, he or she will vote for the merger even if it's a terrible deal, because he's hoping the share price will drop. So you don't allow that. So the disinterested shareholder concept, if you think about it, is basically, in certain contexts, it embodies the foundational premise of the shareholder vote. All right? Now, in terms of this, this doctrine developed, has been around a long time, well before the emergence of the institutional investor. Well, earlier this year, and many of you may have read about this, in a really landmark statutory development, Delaware passed a statute basically modeled on Senate Bill 21. So people tend to refer to it as the Senate Bill 21 law. And the reason Delaware set it up was basically because so many corporations were reincorporating in Nevada, Texas, or elsewhere. Okay, basically kind of an emergency set of statutory changes, and basically regarded as like the most important changes in Delaware law in half a century, something like that. And I should disclose that. That my co-author, Larry Hammermish, was one of the primary drafters of Senate Bill 21. But anyway, so this landmark bill does finally offer a statutory definition of disinterested shareholder, okay, to replace the judicial construct of what a disinterested director. But essentially, this statute did not in any way modernize the construct to reflect these transformational institutional investor changes. Okay? They did not modernize it. And I'll show some of the consequences of that. And in addition to that, what it failed to do was basically did not in any way try to set up a procedural architecture for how you go about determining whether or not, for instance, an institutional investor is disinterested or not. Okay? Now, in terms of this, I'll explain, in a sense, how those kinds of problems come up. But to take a concrete example in terms of why this is relevant to the real world, okay? I want to use a real world case. Okay, so I'm saying these problems with even with after Senate Bill 21. So this is a case involving a potential merger between a publicly held company called CNX, the railroad company, and a company called Consol, which is a coal company. Okay, and T. Rowe Price, a major institutional investor, and this was a couple of years ago. So the judge was using the long-standing judicial doctrine. The judge noticed, look, T. Rowe Price had 6.5% of the acquiring company and 6.3% of the target company, essentially the same, right? And so in terms of the vote at CNX, okay, so CNX is a host company, it basically had a zero overall economic interest in CNX, right? Zero. Hey, I'm not going to count any of T. Rowe Price's votes in terms of whether or not to basically, for the purpose of determining whether or not to give validating effect to the vote. That's, you kick out T. Rowe Price's shares. Okay, but here's the interesting part. The judge did not look at, hey, what if the litigation had not involved T. Rowe Price, but had involved, for instance, BlackRock or State Street? Okay? So my research assistant and I took a look at what BlackRock and State Street seem to own of these two companies. Well, look at it. BlackRock owned 0.03% of CNX, 0.795% of Consol. That is a ratio of 1 to 27. So if you're going to knock out T. Rowe Price for simply having 1-to-1 in terms of the vote at CNX, boy, you got to really knock out BlackRock's votes. Or if you look at State Street, notice it had 0.15% of CNX, but 4.52 of Consol. Both BlackRock and State Street were empty voters with negative economic interest in CNX. Right? But let's think about that. If you knock out, Vanguard happens to be in the same kind of thing as T. Rowe Price. Notice, basically about the same in both. But let's think about that. If there were litigation involving those three companies, the big three, you knock out all the votes of the big three institutional investors. But what are the consequences of that? Well, if you knock out the votes of these big institutional investors, whose votes really make, have much more impact? Anybody? If you knock out these big three, think about it. Hey, individual investors? Hey, but aren't individual investors a source of the properly means problem? And then on top of that, who else are you, in a sense, shifting power to? Activist hedge funds. Notice, in terms of activist hedge funds, they're not diversified. They hold 20, 30 stocks, okay? Typical activist hedge funds. They're going to have a positive economic interest. So notice, in terms of the application of this standard disinterested shareholder doctrine, through complete fluke, that is, without any kind of analysis, you're shifting power to individual investors and activist hedge funds. Look, in terms of individual investors, we've seen the meme stock phenomenon. What do individual investors really know, right? And in terms of the shift in power to activist hedge funds, hey, that touches one of the biggest controversies in terms of whether or not it makes sense for hedge funds to have a lot of power, right? So notice these two shifts are occurring with no thinking. There was no analysis, through complete fluke of the disinterested shareholder. That's not a good way to go. And so, in other words, we have a problem. Okay, the guard in the museum in Oslo did not like, my doing that. Okay. So this slide is not in the PowerPoint, for this presentation that you can download, that you'll be able to download. It's not in that version. Okay. So we have a problem. Okay. So what we are trying to do is, what's a practical way of dealing with some of these issues? So let me start with the substantive half first. Okay, so we have a substantive reconceptualization and procedural reconceptualization. And I'm probably not going to end up having time to talk about the procedural half, but just so that you're aware what the procedural problem with the current doctrine is, basically we show that given the way equity stakes are disclosed, and also stakes in terms of derivatives, also in terms of stakes in terms of short selling positions, the way it works in a normal publicly held company, it's almost impossible to really figure out what the true financial stakes of a major institutional investor is. Virtually impossible to find that out. It's really horrific, okay, in terms of that. And we offer, so there's a basic informational impossibility problem, and we offer some solutions, partial solutions for that informational impossibility problem. So in terms of the time I have remaining, about 20 minutes? Okay. Let me primarily focus on the substantive half, okay, of our proposed solution. So one aspect, notice in terms of the disinterested shareholder doctrine, roughly speaking, it only focuses on financial stakes of the investor, okay? Host shares, coupled assets, related non-host assets, okay? Although they don't frame it. In fact, it's not as sophisticated as that. But essentially, just focus on financial stakes. It doesn't take into account at all what we refer to as organizational voting dynamics. That is certain, for instance, institution-specific voting policies and practices. And we think that's really critical to a solution. Okay? Let me explain. So assume this hypothetical. You didn't realize you were stepping into an exam, okay? This is an exam, okay, in terms of this. Think about this hypothetical, okay? So say that company A wants to acquire company B. And you happen to, the way they structure the deal, you need a favorable vote both at company A and company B, okay? And you're a major asset manager, okay? You're a big-time conventional asset manager. And in the aggregate, across all your funds, okay, that you run, you own 2% of A and 4% of B, okay? You own 2% of A and 4% of B. And you think that A is offering too high a price, okay, to acquire B. And so if the merger occurs, you think that A shares will go down in price, and B shares will go up in price, right? Given how lopsidedly favorable it is to B, right? Everybody see that? Okay, here's the interesting part. So the question is, should we count your votes at A's shareholder meeting? Should we count your votes at B's annual meeting? Okay, well, let's take a look at A. You're voting at A, right? And in terms of the disinterested shareholder doctrine, okay, so where you're simply looking at the financial stakes, okay, of the investor. So notice in terms of T. Rowe Price, the judge didn't break down which fund held which shares. Okay, it just looked at T. Rowe Price basically in the aggregate. Okay, so we refer to the kind of implied assumption of the disinterested shareholder doctrine, the classic disinterested shareholder doctrine, as aggregate portfolio value maximization. So that is, you know, if you adopt that approach, since at A's shareholder meeting, the doctrine basically says, hey, you should not count your votes, right? The court should not count your votes, right? Because 2% of A, 4% of B, right? And you have a, you know, negative economic interest in A, right? Everybody see that part? Okay. And then in terms of at B's annual meeting, yeah, we should count the votes, your votes, because B, you have a positive economic interest in B, so you should count the votes. Okay. In contrast, what we did was we looked extremely carefully at previously unexamined voting patterns at State Street and Vanguard, okay, in terms of what they actually do. And we basically, and we illustrate with concrete examples involving basically this hypothetical, okay, and the details are available in that article you could download. We show that what State Street does is it operates using very different voting policies or voting poll stars, that the poll stars they use to guide their voting is very different. What State Street does is, irrespective of which State Street fund, okay, owns what, all State Street funds will, if it is voting at the A shareholder meeting, will only vote in ways that benefit A, completely irrespective of the fact that it may hurt State Street. Okay, State Street may have tons more B. Well, they have more B, 4%, only 2%. Yet at A, they will vote against the offer. But notice, so State Street, in other words, is voting precisely the way the foundational premise of the vote is. They're voting for transactions that are good. Yet, under the disinterested shareholder doctrine, they knock out State Street's votes. It's crazy. Right? So you're miscounting sophisticated. Who could be more sophisticated than State Street? Well, BlackRock and Vanguard will claim they're more sophisticated. But, you know, there are very few as sophisticated as State Street. You're knocking out sophisticated votes, voting precisely with the motivation you want them to have. Okay? So notice the disinterested shareholder doctrine miscounts State Street's votes. Right? Or Vanguard has a different approach. Okay? So in terms of State Street, it has what we call a whole share value maximization approach. So at A's annual meeting, State Street will vote against the deal. And notice at B's, hey, it'll vote for the deal. So they're voting contrary to each other because at whatever company they're voting in, they're voting in that company's share price interest. Okay? And we show this, we demonstrate this with concrete examples that nobody had looked at before. Okay? Now, Vanguard is different. Vanguard uses what we refer to as a fund-by-fund portfolio maximization approach. Okay? So, and in both State Street and Vanguard's examples, we're talking about the core Polestar they use. With both of those entities, there are certain exceptions. Okay? In terms of Vanguard, the general rule is if they look, say that the Vanguard ABC fund, okay, and the Vanguard XYZ fund have very different looking portfolios, okay? And Vanguard's ABC fund happens to own 2% of A shares, 4% of B shares. Well, that, in effect, that portfolio for the ABC fund will vote in ways that would maximize the value of the ABC fund, okay? In contrast, the Vanguard XYZ fund, let's pretend, right, has it flipped to 4% or 2%, it'll vote in completely the opposite direction. What's good for the XYZ Vanguard fund? So it's a fund-specific approach. So notice there's miscounting that occurs as well, right, with Vanguard. So in Vanguard's case, because overall it has a negative economic interest, hey, under the doctrine, you completely knock out all of Vanguard's votes, even the ones that happen to be voted precisely the way you want them to vote, okay? So in both the State Street and Vanguard cases, there's miscounting that goes on. And so it's really kind of, it's really troublesome. Now, so what, in terms of our partial solution, okay, part of our solution, we have lots of suggestions, but part of our solution is, in effect, that the doctrine should be reconceptualized so it explicitly takes into account organizational voting dynamics of that institution. Under the current disinterested shareholder doctrine, doesn't take into account any of these organizational voting dynamics. So, for instance, one key takeaway from the State Street Vanguard example that I just went through was, notice in terms of State Street, where it follows the host share value maximization approach. Anytime State Street votes, you know they will vote in ways that are beneficial to the share price, that they think will be beneficial. That is, in every instance, State Street should, in fact, have its votes counted, right, because they're consistent with the foundational premise. And so, in terms of State Street, okay, or other companies, investment managers that have publicly announced and have a bona fide voting policy that they will use host share value maximization, we're saying, hey, in those cases, you should count the votes. So notice it solves some of the miscounting problem, right? Or in terms of Vanguard, notice in terms of Vanguard, some funds will vote in ways that, in fact, hurt the interests of A, okay? Because they happen to own more of B. But there may be other Vanguard funds that own more of A than B, and they will vote against the deal. And you should count those votes, right? So what we are basically suggesting is under the current doctrine, it's a very blunt doctrine in terms of classification. Either you are a disinterested shareholder or you're not, very binary. We take a more subtle approach. Hey, that there should be a concept of disinterested shares rather than disinterested shareholders. So, for instance, those Vanguard funds that have a positive economic interest in A, hey, they're owning disinterested shares, and their votes should count. Okay, there's a second aspect of this, and the people in the Chicago school would like this. Notice, this is a private ordering solution, right? That is, if an institutional investor, for instance, wants to make sure that all its votes count, one of the things you can do is adopt a bona fide, publicly announced policy of host share value maximization. We will always vote, all our shares, no matter in which fund it is, will be voted in ways that we think will promote the value of the company. And so notice, with this kind of approach, right, you kind of can leave it up to an asset manager to basically escape from the disinterested shareholder doctrine, right? And so, and this kind of notion in terms of moving away from this blunt instrument in terms of disinterested shareholder to disinterested shares, or interested shareholder versus interested shares, that's also helpful in terms of a lot of what else is going on in the asset manager industry. I don't know whether it's taken hold in Singapore, but in the US, a number of the big asset managers basically allow what's referred to as pass-through voting. Okay, pass-through. That is, and it started on the in terms of the institutional clients first. Now it's kind of percolating down to their retail investors, including investors in mutual funds. That is, even though Vanguard is running the money, right, in various fund portfolios, in certain cases, they will not, in a sense, vote the shares the way they want. Instead, they let the people who have invested in those Vanguard mutual funds decide how they want to vote, right? So in that kind of situation, does, this kind of disinterested doctrine make sense, where, in a sense, completely ignores the impact of pass-through voting? Now, there's a problem here in terms of pass-through voting, because sometimes in terms of pass-through voting, they do things like they give you a menu of choices, and that some of the choices, in a sense, that seemingly come closest to, simply focusing on shareholder wealth, in fact, some of them may take ESG considerations into account, okay? And as we know, certain, not all, but certain ESG-related voting hurts shareholder value, okay? So it's kind of interesting that, at least one fund family has promoted the fact that one of the choices they offer is one that completely ignores ESG considerations, using a proxy service that advisory service that completely ignores it. Okay. Okay. So in terms of the 3 minutes I have left, right? In terms of I was basically pointing out the informational impossibility problem on the procedural side. In terms of our kind of partial solution for that, in terms of informational impossibility, on the institutional investor side, think about what you need. You need to know, right, the Perry example, Perry Malley, you need to not only know their holdings of the shares, the host shares, but you need to know all their coupled assets, i.e. short positions they have. Hey, in the US, short positions are not publicly available. Okay? And in terms of, you also have to know, like, for instance, the put options or call options they have, right? Well, in the US, OTC derivatives are not subject to disclosure, okay? Yeah. And so that's on the institutional side. In terms of individual investors technically are also subject to this disinterested shareholder doctrine. Well, McDonald's in the latest 10K indicated that they estimated the number of beneficial owners of McDonald's stock is something in the range of 2 million. How the heck do you get information relating to 2 million shareholders? And you're saying, oh, gee, don't the companies have a registry of who their owners are? Not in the US, because in the US, because of the operations of a system involving a company called DTC, Depository Trust Company, in effect, the shares on the books of the host company are in street name. Technically, the institutional investors have the right to be a so-called NOBO, non-objecting beneficial owner, in which case the host company will know that XYZ institution holds your shares. Well, guess what? Not surprisingly, institutional investors are loath to give up information on what they own, okay? So even the host company doesn't know. And in terms of SEC disclosure mechanisms, so even in terms of just the plain vanilla host shares, leaving aside 13D, 13G, which kick in when you have 5% or over, if you're below that, you basically rely on a form that's publicly available called Schedule 13F, as in Frank. Well, guess what? The 13F information is only required on a quarterly basis, and you have 45 days to file that information. So think how dated that information. Some institutions get in and out of a security on the same day, right? So information impossible. So I guess I'm out of time. In terms of the procedural part of a reconceptualization, basically involves a set of completely changing the initial presumption. That is, under the standard disinterested shareholder doctrine, you, if you want to vote, have to prove you're disinterested. We change it, we reflip that. We basically say, hey, you should assume initially that you are disinterested, but make it rebuttable, and through all kinds of means. Okay, but in conclusion, the gap between vision and reality in terms of the stockholder franchise is widening, in part because of transformative institutional investor changes that seem to be secular, okay? They're continuing. And application of the core legal response to these motivational misalignments basically silences or distorts the voices of shares being voted precisely the way the foundational premise envisions. And in terms of solutions, I want to emphasize that our solution is not a perfect solution. That is, on the left-hand side is the perfect hotel, the hotel sphere that doesn't exist, by the way. It's a hotel that is meant to be carved into the side of a cliff overlooking the Arabian Sea. Okay, it's called a hotel sphere. The other hotel is more realistic. It's called the It'll Do Motel, okay, the one on the right. Now, so our solution is not meant to be the hotel sphere, but hopefully at least marginally better than the It'll Do Motel. Okay, so thank you so much for hearing me out. I really appreciate it.
Thanks very much again, Henry. I guess it's a prerogative of the chairperson to ask the first question, and I think I'll kickstart. I hope this suggestion isn't the motel that's there, but sometimes there is something about going back to an initial old traditional way of doing things. I was just wondering whether class voting is something that's possible. So for us, when it comes to restructuring schemes of arrangement, those of you who do insolvency law would know this far more than I. You go to before the court, and the first thing you ask is whether you can structure the voting amongst various shareholders and creditors in a certain way. There was a high point in this where even people with differing interests had to be put in different classes, but it looks as if you have to have different rights. So I guess ordinary shareholders and preference shareholders are different. But there is a possibility of us saying that institutional shareholders today could be put in a different class. So we don't ask about their disinterestedness, but we just say all of you are in one class and the retail shareholders are in another class. And you need to get 50% of either or both of them. Yeah, and you can structure it in different ways. You can say, so long as one class says yes, so long as the other class isn't too negative, you can go ahead with it. But the simplest solution is to say both or three classes or however many classes must have a majority that says yes to it. So just wondering what you think about this sort of old world way of doing things.
Right. Well, the situation I was talking about is the typical situation of a one share, one vote company. Of course, we know there are lots of dual class share companies now, especially in the tech area. Some of the big tech giants have dual class voting. But in a sense, some of the kinds of issues that you're talking about really don't go away, even if you have, say, several classes of shares grouped by whether you're an individual investor or institutional investor. Because say that you own institutional investor shares. What's to prevent that institutional investor from buying put options on those shares he owns? And if they don't exist, hey, you'll talk to a derivatives dealer and he'll gladly sell you one, right? And so the kinds of issues simply, still exist if you break it down that way. And so the field in which the decoupling occurs changes, but the problems, I think, basically still remain.
So there was a high point in English law where even if the shares were the same, so it's one share, one vote, but the person who's holding the shares, the characteristics of this person could change the share. And at that high point in English law, they would say that this person had to be put in a different class from other people, even though everyone had the same shares. So just wondering whether you can therefore say, institutional shareholders, we don't know what your motivations are, but all of you are in one class. Retail shareholders, perhaps in another class, and you need to get a majority of each class. I know it's probably not workable, it's just something to think about.
Well, but let's think about institutional, they vary a lot. Some institutional investors explicitly take ESG into account, even if it harms shareholder interests, okay? So when you think about it, their votes are contrary to the foundational premise of shareholder. And indeed, one of the reasons that BlackRock pulled out of Climate 100 a few years ago was basically, in terms of the US funds they manage, they basically said, hey, it may violate our fiduciary duty under US law to do that. And so you have, and in terms of the people who tend to promote kind of ESG concerns, and I'm not necessarily saying that these people are for, counter, the types of ESG that can hurt shareholders, but the ones that in the US, in contrast to Europe, the ones who still are kind of in that ESG camp tends to be public pension funds. And so in terms of public pension funds, they've had concerns, for instance, in terms of public pension fund voting, in terms of their influence on boards. Hey, they will, they may not want their company to relocate their corporate headquarters from where the public pension fund is located, right? to, some lower cost city. And so, you're lumping in like people with so many different kinds of interests, and also in terms of institutional investors, I was cheating a little bit in terms of transparency, because when you think about most ETFs, not all, but most ETFs, at least in the US, and I assume elsewhere, disclose on a daily basis their holdings, right? And they need to do that because the authorized participants need to know what's in their portfolio in order to play their arbitrage games that would cause the net asset value to converge to the trading price during the course of trading day. So if you're talking about ETFs, you really have a heck of a lot of information. But the other end of the spectrum, say you're talking about a sovereign wealth fund, right? A sovereign wealth fund, or in terms of certain private pension schemes. In the US, it really varies in terms of the state, how much they have to disclose to supplement SEC information. Or there's a vehicle that's increasingly popular, may soon displace mutual funds in terms of the 401k plans, the main retirement scheme in the US, called collective investment trusts. There, the transparency of the collective investment trusts are well short of what mutual funds, for instance, disclose to investors. And so, if you end up with one rule, you could end up with a system where, in effect, where it's going to be wrong, right, in terms of certainty and others. So, unfortunately, life is complicated, but academics suffer from have a real moral hazard. Okay, academics have a real moral hazard. We love disasters because disasters give us room to work, right? To provide solutions and provide us an excuse to plead for research grants.
So I have a question about strategic voting. So we know that funds have very different interests. Pension funds have very different pecuniary and non-pecuniary interests as compared to the big three, and in turn the big three have very different interests from an activist hedge fund. But what makes this problem even worse is that voting can be correlated. So if you vote yes, I might vote yes, not because my interests are in line with my own so-called objective function, or the lay person term would be my interest, but because I'm voting yes because strategically it makes sense for me to vote yes because you and everyone else is also voting yes. So this strategic element seems to confound the information problem for the courts. And I'm wondering whether you have any solution to this. Thank you.
Well, we have a really long footnote pointing out how we differ from the common ownership literature, the cross-ownership literature. For one thing, the cross-ownership literature is very naive in terms of how they evaluate the financial interests of companies. So they tend to simply look at holdings of shares, in common stock in the two companies, right? They typically do not look at any derivatives holdings. How the heck do you do that? Yeah, it'll make it more intractable, okay? But that's not really an excuse. And they don't take a look at short positions. They don't take a look at put options and things like that. And so the common ownership literature is really not very satisfactory. Also, in terms of the common ownership issue, of course there are serious antitrust issues and so forth. But I think that they haven't looked carefully enough at the actual incentive structure. And notice at the very beginning of the presentation, I was basically, pointing out that I'm ignoring other things that may influence, that motivate institutional investors other than decoupling. So, for instance, the pension example that I'm referring to, in the footnote, we refer to allegations that came up in terms of the Hewlett-Packard Compaq merger. Now, allegations, the court ultimately rejected the allegations, I emphasize, but the allegation was that Carly Fiorina, then chairman of Hewlett-Packard, went to Deutsche Bank and basically said, hey, you vote against this merger, bye-bye pension business, okay? So that's an example that's not captured by what we're doing, right? The side business. Or you could have familial relationships, right? The familial relationships, or social relationships that may affect your voting. And, in lots and lots of situations, right, the club of people who serve on boards, there's a remarkable degree of, cross-directorships, right? And boy, those things could, so I'm guilty, so we're guilty of the same kind of tractability issue. That is, we're looking at, something that's more tractable, like concrete, right, in terms of quantifiable, in terms of these interests and so forth. And we acknowledge completely the impact of these other aspects. And I should point out, for instance, in Delaware law, as you know, Delaware to corporate law is what Saudi Arabia is to oil, what Taiwan is to chips, okay? It's be all and end all. And in terms of Delaware, it's always been understood that you have to take into account these kinds of relationships and these other factors. And we're not saying you shouldn't do that. And in the new statutory definition of disinterested shareholder, they really do, they actually put in the definition the concept of material interest in terms of these other relationships. But I think that's part of the research, part of the research agenda. It'll be part of the pleading for more research grants.
If not, maybe I'll just carry on with the story, because yours is a sort of a moving matrix to determine disinterestedness. I just wonder whether we can throw another span in the works, and it depends on the kind of decisions that's at stake, right? So there are situations perhaps where the whole idea of getting the person who is disinterested becomes more vital. So, for example, in a delisting, because we've been going through that, as you've seen with the OCBC Great Eastern, compared to Elon Musk's completely undeserved salary asking, but that's not as important as the delisting. So it could just be that disinterestedness is more important in the first, and maybe we're not so careful. We don't have to be so careful in the second.
You touched on a really important point. And in terms of Elon Musk, remember I was talking about the difference, basically, in terms of the cleansing effect of a favorable vote of disinterested shareholders. If you get the cleansing effect, that is enough disinterested shareholders vote for you, instead of applying strict scrutiny or enhanced scrutiny, you flip over to the business judgment rule. And of course, the business judgment rule, bingo, you win, right? Because with the business judgment rule, basically the judge essentially doesn't look very much at all. Well, in terms of the Elon Musk, as you're all familiar with the Tornetta decision in January of 2024, where the Delaware Chancery Court, the Chancellor, Kathleen McCormick, applied enhanced scrutiny, okay, because she felt that the disinterested shareholder vote was necessary. And under enhanced scrutiny, one of the elements was not only that it's the vote of the disinterested shareholders, but they had to be well informed. And she was convinced that under the standard, she would reject a $55 billion payout $55 billion payout to Elon Musk. So, in fact, this decision was one of the major reasons why a number of companies decided to reincorporate elsewhere, because you had Delaware judges actually, stepping in. In terms of when the disinterested shareholder matters or not matter, it's an interesting issue because we haven't talked very much about the impact of share lending and share borrowing. Okay. Basically, in a share lending transaction, the person who lends the shares, okay, for instance, a mutual fund or a pension fund might lend the shares. It keeps the economic interest of the shares. But technically, the person who borrows the shares, such as a short seller who needs to borrow the shares, technically that short seller is the owner, and so has the voting rights. So there's a famous example right around the Perry Milan era, and we talked about this in our initial decoupling article back in 2006, where Laxey Partners, a hedge fund, owned 2% of British Land. And they were making the usual complaints about British Land, lazy management, incompetent management, all that kind of stuff. And the incumbent management of British Land didn't care one bit about Laxey because, hey, they only own 2%. And there was no indication they were contacting other shareholders, okay, to engage in wolf pack behavior. Come the annual meeting, Laxey, instead of voting 2%, votes 8% of the shares. And they were shocked because there was no spike in trading volume on the London Stock Exchange of British Land. Well, what had happened? What Laxey did was simply just before the record date borrowed 6% of the shares. And just by paying a few dollars to borrow the shares, they would vote 8%. Okay, of course, incumbent management was just apoplectic to the point that they actually forced a whole bunch of institutional investors to hold a press conference, kind of apologizing for having lent the shares. Okay, but in terms of how this relates to your point, so institutional investors routinely lend out the shares to basically to get the income from lending shares, because they still have the economic interest in the shares, okay? But they realize that sometimes it may affect the vote, right? If they lend the shares, right, out, and the people who borrow the shares, some hedge funds or whatever, it might affect the vote. So sometimes, and we talk about this in the article, so we point out explicit policies where if they think the vote is, in a sense, material enough, there are lots of shareholder voting that's silly, doesn't make, or if they think the vote is going to be close, okay? If they think the vote is material and the vote is going to be fairly close, they may recall the shares so that they can vote. But when it doesn't matter, i.e. it's immaterial, or when the vote is going to be lopsided, hey, why bother, right? You're just leaving money on the table, okay? So does that help address?
Yeah, very much. And it also brings us right to, 6:38, just right. It remains us to first thank Henry for coming all the way out here from Texas once again.
Well, thank you.